Let's turn to another top focus tonight. The Gujarat Assembly today passed the controversial Control of Terrorism and Organised Crime Bill by a majority vote. This bill, a proposal made by Narendra Modi when he was Chief Minister of Gujarat, has been rejected not once but 3 times in the years 2004 and 2008 by then Presidents APJ Abdul Kalam and Pratibha Patil. First, let's take you through some of the extreme provisions of this terror bill. Why is this bill provoking so much of controversy? Now, confession before a police officer will be admissible as evidence in court as per this bill. That's the controversial provision number 1. The bill doubles the period a suspect can be kept in custody from 15 to 30 days. The third crucial provision. On prosecution's recommendation, charge sheet can be filed within 180 days, not 90 days. So that's another third controversial proposal. The question is, of course, is this draconian or simply the need of the hour? Just listen into those voices. Why is this bill, first moved by Prime Minister Narendra Modi when he was Chief Minister, creating such a controversy? Our top story.
The Gujarat Assembly has passed the Gujarat Control of Terrorism and Organised Crime Bill. The provisions of the contentious bill has already created a storm with the opposition and civil rights activists up in arms.
तो ऐसी बात करके गुमराह करके वोट बैंक की पॉलिटिक्स के लिए आज उसको मिलाया, इसका हमने विरोध किया। जब हमारी बात नहीं मानी गई, टेक्निकली हमने जो बात समझाई वो भी सरकार ने नहीं मानी, तो हमने आज वॉकआउट किया।
कोई संगठित गैंग से कोई गुनाहित कृत्य होता है या प्रजा को, नागरिकों को, सिटीजन को असलामत करने वाला कोई भी कृत्य होता है या राज्य की सलामती को कोई नुकसान हो, इस प्रकार का कोई कृत्य होता है तो उसको रिस्ट्रिक्ट करने के लिए और ऐसे काम करने वाले गुनाहित आतंकवादी तत्वों को जहर करने के लिए इस कानून में प्रावधान किए गए हैं।
Gujarat's anti-terror bill is an old wine in new bottle. The bill, which was written thrice by earlier president, was introduced today in Gujarat Assembly after renaming it. Gujarat Assembly today passed this bill, but the most important thing is that the controversial clauses remain in it.
The contentious provisions of the bill include admissibility of evidence collected through telephonic interception and confession made before police officer as evidence in court. Also under prosecution's recommendation, the police could get 180 days instead of 90 for filing of charge sheet. 3 clauses that the opposition claim will lead to harassment of suspects. The bill's fate has been hanging in the balance ever since 2004 when Modi was Chief Minister of Gujarat. And once again, its future lies in the hands of the President. Bureau Report, Headlines Today.
Big question, of course, Gujarat's anti-terror bill. Is this draconian or is it, as the Prime Minister has often claimed, the need of the hour? Is this Modi's pet terror bill? Let's raise that question, and special panelists will join us. Dushyant Dave, Supreme Court advocate, comes from the state of Gujarat. I'm also joined by Vikram Singh. He is a former DG of police, so we'll get the legal and police perspective. And we'll also get the political perspective today from the Congress and BJP with Sudhanshu Mittal of the BJP and Amiben Yagnik of the Congress. I want to come first to the politicians and then I'll come to the 2 experts from law and the police. You know, the fact is, Amiben Yagnik, the Congress party, which is objecting to this bill, has passed exactly a similar law in Maharashtra. You have Makoka, the Maharashtra Act, the Maharashtra Control of Organised Crime Act. So when you pass Makoka, you don't have problems. But when Narendra Modi and the Gujarat government pushes ahead with the anti-terror bill, you have a problem. Why these double standards, ma'am?
There is a question of double standards. If you see Makoka, he doesn't have the word terrorist, it's organized crime. And continuous comparison with Makoka and Guchkok, I think you're drawing some very strange comparisons.
No, I'm not. I'm sorry to intervene, man. The fact is, a suspect, even in Makoka, can be kept in custody for 30 days. The police can take 180 days to file the charge sheet. So all your criticisms against this Gujarat anti-terror bill will also operate for the Maharashtra one. Simply there was a Congress government when you got this bill passed.
No, if you see both the acts, why then they were not passed? They were sent back by the president twice, and the third time it is pending, and now you have changed the nomenclature to bring the word terrorist, and you have trying to pass the bill.
Because your government put pressure on the then president. Particularly your government put pressure on President Pratibha Patil to reject Narendra Modi's bill. That is the truth.
No, but there was practically no changes. Only cosmetic change was made, and today they have changed the nomenclature. The point is that why there is such inherent flaws in the act, the bill has to be passed. Why this obstinate attitude to give sweeping powers to the government machinery? Why do you want to use that? Why can't you have the perfect law and order situation to curb all these menace which you think is organized crime or terrorism in Gujarat?
You know,
on one hand you say that there is nothing in Gujarat.
What
why
you're
do
saying.
You need the Gujarat?
I will ask my producer to focus on this at the moment, but I want to first bring in Sudhanshu Mittal. Sudhanshu Mittal, the fact is it's not just Pratibha Patil who rejected it. This bill was also rejected by President Kalam when he was President of India, and the particular worry at the time that the President had expressed was the manner in which it gave sweeping powers to the police to tap phones. Why is this now simply because you have a BJP government at the center, BJP government in Gujarat, you've decided we are going to ram through this anti-terror bill come what may?
Rajdeep, the worst kind of politics was played with this bill in Gujarat by the Congress party in the center. You rightly pointed out that the Makoka has exactly the same provisions. Section 14, Section 17, Section 18, they are identical to what is there in the Gujarat Act. But while Makoka was acceptable, because it was Narendra Modi's act in Gujarat, no, the center said, no, this is not acceptable. Without explaining why Makoka was acceptable and this was not acceptable. I just try and bring to the notice of the Honorable Lady that, ma'am, Kassab was hanged, in which a very substantial part of the evidence which was upheld was under Makoka itself, where it was admissible because he had said so in front of the investigating officer. That was the provision.
No, I am asking you, no one says that there should not be tough anti-terror laws. I am asking you, Sudhanshu Mittal, the government of Gujarat brought this bill before President Kalam. You brought it before Pratibha Patil. It was rejected on 3 occasions. The specific provision which was objected to by President Kalam was the one which gave sweeping powers to the police to tap phones. Now, without changing anything, you've gone ahead with the bill. Why do, the fact is presidents have questioned your bill, Pratibha Patil and Kalam. Are you saying that it was done under influence of the Congress government?
Absolutely, we had said that earlier also. This was not bona fide, because while Makoka has the same provision, what is Section 14 of Makoka? It says the same thing. What is Section 17? What is Section 18? I have the bill in front of me. This is the Makoka here. It's exactly what the provisions are there in the Gujarat bill. So while nobody objects to Makoka because there it was a Congress-ruled state, you have problems with the Gujarat bill.
Can I just bring in? I think I've understood the politics. I've understood the politics, and I think we now need to look at the law and the police perspective. Dushyant Dave, from a legal perspective, is this bill draconian or is it simply the need of the hour? The Gujarat government and its spokesperson says, we are a state which is a border state. We are a state which has been affected by terror. We need a tough law.
Rajdeep, let's keep politics apart. Whether Makoka is good or bad, that's not the issue. Issue is about the constitutional rights of the citizens and the constitutional obligations of the state. Now, I will begin by reading a few lines of a judgment of the Israeli Supreme Court, where, challenge against on account of terrorism is perhaps the highest in the world. There was a 1999 decision where Israeli, court was confronted with the issue whether this kind of draconian measures, third-degree method, should be administered on terrorist-related crimes on prisoners. And the Israeli Supreme Court rejected the right of the prosecution to do that by these words. And these words are absolutely apt for us today. And I quote them. This is the destiny of democracy, as not all means are acceptable to it, and not all practices employed by its enemies are open before it. Although a democracy must often fight with one hand tied behind its back, it is nonetheless the upper hand. Preserving the rule of law and recognition of an individual's liberty constitutes an important component in an understanding of security. Now this is the approach. You have today Article 20 against self-incrimination. So your provision which says that admissions can be recorded by an officer of superintendent of police and above, according to me, it requires a serious relook. Secondly, right to privacy under Article 21. If you are going to start intercepting people's telephones, computers and other mechanisms, then you are really making serious inroads into the right of privacy.
How do you respond to what the Gujarat government spokesperson is saying, that we are a state which needs these strong laws? These strong laws are no different to what it is in many other parts of the country and indeed in the world. We need stronger laws.
I began by reading this judgment of the Israeli Supreme Court to you, Rajdeep. That's a complete answer to what the
Can I enlighten you on something, Rajdeep?
Quickly, Sudhanshu Mittal, and then I will bring in my police officer, Vikram Singh. Quickly, Sudhanshu Mittal.
Rajdeep, Dushyantji will recollect that the provisions, the 14, 16 and 14, 17 and 18 were challenged in the Supreme Court. Using the same arguments which Mr. Dushyant is using right now. And the Supreme Court upheld the validity of this act. So I do not know which law must be followed. A judgment of Israeli Supreme Court should be followed, or a judgment of the Indian Supreme Court should be followed. The Supreme Court of this country has looked at all these issues and has decided to fight terrorism. These laws are valid. Once a seal of approval has been given by the Supreme Court, I think this becomes a fallacious discussion.
Can I just bring in, Dushyant, the idea of individual liberties? Is that far more preeminent over the belief that you need a stronger anti-terror law?
Let me say one thing to Mr. Mittal. He is right that Supreme Court of India has upheld in the past many laws, including TADA and PUTA, many of the provisions, and Mokoka. But let us, things have changed now. There was a time when Supreme Court looked at these challenges only from the perspective of legislative competence. Today, the law is expanded very seriously in last couple of years. For example, Section 6A of the Delhi Special Police Establishment Act, whereby it was absolutely necessary to take a sanction before you could move under Prevention of Corruption Act against a joint secretary and above. Supreme Court struck it down. While striking it down, Supreme Court has now brought into this the field of arbitrariness. The court says that if any of these provisions are arbitrary, violative of Article 14, then they can be struck down. So you are also reading now, Supreme Court is also reading Article 19 into Article 20 and 21 in
Can I
recent
for a moment?
So
can I hold you, Dushyant, can I hold you? You use the word arbitrary, and I want to take that to Vikram Singh, because the fear, Mr. Vikram Singh, you're a former police officer, the fear is that the police will misuse these laws. They will tap the phones randomly, possibly. They will also ensure that a charge sheet is not filed for 179 days. Evidence will be admissible when a person is under police custody. And all of this will be used, in a sense, to perhaps lead to an arbitrariness that we saw in the earlier TADA laws in the 1990s. It will be used to target either communities or individuals.
Rajdeep, let me react. Firstly, these apprehensions are ill-founded. Terrorism is a very different ballgame altogether, and the investigation and the trial, you have to put your best foot forward. We have Makoka, but don't forget that we have the National Security Act, where detention up to 12 months without trial is a possibility all over the country. Secondly, confession before a police officer has held on its own because it is recorded by an officer of the rank of superintendent of police and not below. There is a review committee in every state where these laws are applicable, headed by the Chief Secretary.
Sir, but it is subject to misuse, and as you know, even in the 1990s when Tada was there, it didn't stop terror. Will strong laws alone prevent someone who's a fidain? Would a Kasab have not come to India for 2611 simply if there was a stronger law in place? Let's be clear. Do laws prevent terror?
Alone, it is the ecosystem in which they operate, the sleeper cells, the cohorts, the silent people who go and aid and abet terror. It can be a very major deterrent in containing and controlling terrorism. Yes, on its own alone, perhaps not. But it is indeed the need of the hour to have such stringent and strict laws strictly enforced. We are discussing the confession made before police officers. How do you expect a common man to, in fact, depose before the court?
So you're saying a confession before a police officer must be admissible?
Perhaps will have the fact that the police officer and give his testimony without fear or favor. Therefore, these laws are absolutely required and are required in the interest of the nation. And all the apprehensions expressed are ill-founded, and in fact, we do respect liberty and in fact the privacy of the citizens, but not at the cost of the national security.
Sir, I was only going by past experience in Tada, which clearly said that the police at the time often misuse these stringent provisions. But Ami-Ben Yagnik, the flip side is there must be zero tolerance for terror. The flip side, Ami Yagnik, is that there should be zero tolerance of terror. And the manner in which the Congress has chosen to oppose an anti-terror law in Gujarat only seems to be because Narendra Modi was the architect of this law. It's not the provisions, it's the fact that Mr. Modi was behind it. So that's the politics of terror.
Yeah, I think Rajdeep, if you recollect...
No, please, Sudhanshu, please let Ami-Ben speak.
Achha, sorry. Okay.
Ms. Yagnik.
Yes, Rajdeep ji, it is only keeping in mind the vote banks and harassment, There is nothing like that this law is going to bring some great change and the crime is going to be controlled or the terrorist acts are going to be controlled. They just want to give sweeping powers to the government machinery.
No, is your objection to the law or to the fact that Narendra Modi has authored it?
You cannot...
Is your objection to the law or to the fact that Narendra Modi has authored it?
No, earlier also it was the NDA government that had come up with these acts and they had to be repealed because you are definitely doing unconstitutional, you are bringing unconstitutional law, you are playing with the liberties of the citizen, and thirdly and most importantly, it is at the whims and fancies of you that you are bringing these acts. Why don't you have a proper implementation of the Criminal Procedure Code? Why you want to override the Evidence Act, which is Central Act? Why do you want to expand all this in order to see that the government machinery can use this arbitrarily and see that you can put fear instead of curbing terrorism? You are trying to put fear and you are trying to have some kind of a vote bank politics.
You're saying vote bank politics, you're saying fear. Sudhanshu Mittal, existing laws not good enough? Is that what the Narendra Modi government believes? Existing laws in this country not good enough to take on terror?
Rajdeep, she has not answered. Why did they enact Makoka, which has all these so-called draconian provisions which she is enlisting and calling them ultra-virus the constitution? Miss, please respond. Why did Congress bring this act? Why did it support this act? Then I'll expand my argument.
So you're basically saying the Congress is guilty of double standards. Let me then get Dushyant Dave to tell us.
Absolutely. They have been playing politics.
Dushyant Dave, does this country need...
Just 1 minute.
No, just a minute. Dushyant Dave, does this country need a clear, concise anti-terror law equally applicable to every state? Therefore, the arbitrariness of one state having Makoka, another having Gujkoka, and this debate between BJP and Congress can be ended once and for all. Is that what we need now?
I don't think country needs any such law. Frankly, I don't think Mr. Singh is at all right. He has a policeman's perspective. He doesn't have a citizen's perspective. I don't think police has ever respected constitutional rights of citizens at all. But let me remind them, both my good friend Mr. Mittal and Mr. Singh, about the words that Supreme Court spoke way back in 1961 in a Constitution Bench judgment. And it said very, very strongly at that point of time, we are talking about good old days. For long it has been generally agreed among those who have devoted serious thought to these problems that few things could be more harmful to the detection of crime or conviction of the real culprit. few investigators, a few things more likely to hamper disclosure of truth than to allow investigators or prosecutors to slide down the easy path of producing by compulsion evidence, whether oral or documentary, from an accused person. And they said this is the first step on the slippery path. Now, way back
but you must understand, Dushyant, you must understand, I take your point, but remember we live in 2015, where we have to combat this hydra-headed monster called terror. Therefore, unusual circumstances will perhaps demand possibly new ways of tackling terror, including stronger laws.
I will answer straight away. You know, I was appointed as amicus curiae by the Supreme Court in a case which involved compulsory administration of narco-analysis tests, lie detector tests and brain mapping tests. And every state Advocate General and then Solicitor General, my good friend Vahanvati, wanted that right to be administered without the consent of the accused. And the three judges accepted my argument after long debate on the ground that mere threat of terrorism is not good enough to take away the basic constitutional human fundamental rights of citizens.
That's what it's coming down to. Therefore, I want to give Vikram Singh as a police officer the final word. That is the debate. The core of the debate is whether a police officer should be given, under the guise of curbing terror, the kind of sweeping powers that Gujkoka and indeed Makoka and Maharashtra also give. Forget Congress, BJP, it's about the law. Final word.
Mr. Rajdeep, nation first, and let me tell you, it's my painful duty to contradict Mr. Dave. The policeman is second to none in its commitment to the Constitution of India and the dignity and of the personal liberty of the citizens of this country. Having said that, let me tell you that these laws are the need of the hour, and in fact, any weapon, any statute is open to misuse. It is the man behind the machine, it's the man behind the law, it's the one who implements his mindset, his training, that is responsible. We can quote extempore from Israel and from any number. A single swallow does not a spring make. At the same time, if we do not, we in fact would be missing an opportunity in history.
I'm going to leave it there. I'm going to leave it there. I put it right at the top tonight because this is a law which deserves a wider debate. This deserves a wider debate, and the question is whether Pranab Mukherjee, Sudhanshu Mittal...
Politics of terror should end. You see,
forget the politics, it's about the law.
Indulge in politics on terror.
Okay, forget the politics. It should be about the law.
A stringent law is the need of the hour. We have to fight terror with all our might.
Sudhanshu, you made your point. You made your point, Mr. Mittal. You made your point, sir. Thank you very much.